CPD training, Secure Electronic Signature Regulations, Canada Evidence Act and PIPEDA. Welcome to this 15-minute Microlearning CPD course on Secure Electronic Signature Regulations in Canada. In today's fast-paced digital environment, the use of secure electronic signatures is no longer optional, it's essential. Whether you're working in legal practice, compliance, or IT, understanding how electronic signatures are regulated in Canada is critical to protecting data, ensuring privacy, and upholding the integrity of digital transactions. This micro course is designed to give you a quick, clear, and practical overview of how secure electronic signatures work, and more importantly, what makes them legally valid under Canadian law. In just 15 minutes, you'll learn the legal definition of a secure electronic signature, explore the technical process behind it, from hashing to validation, and understand the legal presumptions that support its evidentiary value in court. We'll cover key legislation, including the Personal Information Protection and Electronic Documents Act, the Canada Evidence Act, and the Secure Electronic Signature Regulations under SOR/2005-30. By the end, you'll have the knowledge and confidence to identify compliant signature systems, evaluate digital signature certificates, and understand the role of certification authorities in maintaining trust. Let's get started. Introduction. Welcome to this continuing professional development course on Secure Electronic Signature Regulations, the Canada Evidence Act, and PIPEDA. As online transactions increase rapidly, so do the risks of fraud, errors, and impersonation. Electronic signatures are increasingly replacing traditional handwritten signatures, offering convenience and efficiency. However, this shift also introduces new opportunities for errors, fraud, and procedural failures that can undermine document authenticity and legal compliance. This course will provide a comprehensive overview of the key legal frameworks and technical standards governing secure electronic signatures in Canada. A legal framework overview. The Secure Electronic Signature Regulations under SOR/2005-30 establish the technology and procedural requirements for valid, secure electronic signatures. These regulations work alongside the Canada Evidence Act and the Personal Information Protection and Electronic Documents Act, PIPEDA. Key definitions. Act refers to the Secure Electronic Signature Regulations. Asymmetric cryptography uses pairs of mathematically related keys, a private key and a public key, for secure encryption and decryption. Certification authority, a trusted entity authorized to issue digital signature certificates. Digital signature certificate, an electronic document that identifies the certification authority, the individual signer, and contains their public key. Hash function, a one-way mathematical process that converts electronic document data into a unique message digest, ensuring the integrity of the data. Technology or process for secure electronic signatures. A secure electronic signature is created through several consecutive operations. 1. Apply a hash function to the data to generate a unique message digest. 2. Use the private key to encrypt the message digest. 3. Incorporate or attach the encrypted digest to the electronic document. 4. Transmit the document and encrypted digest with either a digital signature certificate or means to access one. 5. Upon receipt, the public key decrypts the encrypted digest. The hash function is reapplied to the document data to produce a new digest, and the two digests are compared to verify integrity. 6. Validate the digital signature certificate for readability, expiration, and revocation status. Validity of digital signature certificates. A certificate is valid at signing if it is readable by authorized parties, unexpired, and not revoked. Supporting certificates must also meet these validity criteria. Presumptions under the regulations. When a secure electronic signature process compliant with the regulations is followed, there is a presumption that the signature is valid and that the electronic document is authentic and unaltered. This presumption supports the admission of electronic documents as evidence unless contrary evidence is presented. However, if the process is not fully complied with, these presumptions do not apply, and additional evidence will be required to prove authenticity and integrity. Burden of proof. Canada Evidence Act. Under Section 31.1 of the Canada Evidence Act, any person seeking to admit an electronic document as evidence bears the burden of proving its authenticity. The proof must be sufficient to support a finding that the electronic document is indeed what it claims to be. This burden includes demonstrating the integrity of the system in which the document was created, recorded, or stored. Section 31.2 states that the best evidence rule is satisfied either by proving the integrity of the electronic document system or applying an evidentiary presumption established under Section 31.4, such as those arising from compliance with secure electronic signature regulations. PIPEDA definition and requirements. Secure electronic signature, one resulting from a technology or process prescribed by regulations. The Governor in Council prescribes technologies, processes only if the signature is unique to the individual. The individual has sole control over applying the signature. The technology enables identification of the individual. The signature is linked to the document so changes can be detected. Supporting evidence requirement. Even a secure electronic signature must be supported by evidence proving the document is unaltered and from the stated sender. Example non-compliance phrases 1. The organization failed to provide evidence of consent, such as a checked "I agree" box or signature on a clearly worded consent form, supported by a secure electronic mechanism or digital signature certificate. Absence of a checkbox indicates an invalid electronic signature. Additionally, any electronic signature process used did not meet security and authentication standards. 2. The organization failed to implement technological safeguards such as secure electronic signature technology or a process ensuring that the electronic signature is unique to the individual using it, that the individual has sole control over incorporating, attaching, or associating their electronic signature with an electronic document, that the technology or process can be used to identify the individual, and that the electronic signature is linked to the document in a way that allows detection of any modifications after its incorporation. Example 3. Failure to comply with Section 2 of Secure Electronic Signature Regulations. The organization failed to meet the requirements of Section 2 of the Secure Electronic Signature Regulations. It did not provide a digitally signed document with a valid certificate, apply a cryptographic hash function, or encrypt the resulting digest with a private key. The encrypted digest was not properly associated with the document, nor was the document transmitted with a valid certificate or a way to access one. Signature verification upon receipt was also not performed. Alternatively, the organization failed to provide any digital signature certificate at all, and as a result, no presumptions under Section 5 of the regulations can apply. Example 4. Failure to provide the original electronic document with a secure electronic signature as required by PIPEDA. Section 37. The organization failed to provide documentary evidence of compliance with the federal requirement to retain documents. In particular, it did not establish that the electronic documents were A. retained in the format in which they were made, sent, or received, or in a format that preserved the original information, B. readable or perceivable by authorized individuals, and C. accompanied by information identifying the origin and destination of the electronic documents, as well as the date and time they were sent or received, contravening Section 37 of PIPEDA. Example 5. Failure to ensure electronic signature security and document integrity. The organization failed to implement electronic signature security features necessary to protect personal information. A secure electronic signature system ensures document integrity by locking the document after signing. Any attempt to alter the signed document would either break the signature or trigger a warning, preventing tampering. The organization did not implement document authentication mechanisms to confirm the signer's identity, which is necessary to prevent unauthorized individuals from signing on someone else's behalf. Additionally, it failed to implement audit trails that track all actions taken, such as who signed, when, and from where, creating a verifiable history to detect fraud and confirm consent. Example 6. Failure to secure electronic documents and ensure system integrity. The organization failed to demonstrate that it configured a secure electronic document system to prevent errors, resulting in an unreliable and unsecured application process. This indicates the use of electronic systems without appropriate safeguards, such as secure electronic signatures, to ensure the integrity of electronic documents. Example 7. Failure to obtain irrevocable express consent via secure electronic signatures. The organization failed to demonstrate that it obtained irrevocable express consent by failing to implement secure electronic signatures and did not consider the reasonable expectations of individuals for express consent required for sensitive financial information when it failed to implement secure electronic signatures. Example 8. Lack of secure electronic signature and digital certificate evidence undermines document authenticity. The organization failed to provide evidence of a secure electronic signature and did not provide evidence of a digital signature certificate. In the absence of secure electronic signatures, there is no legal binding evidence to support that the data in the electronic documents was signed by the person identified or could be identified through a valid digital signature certificate, resulting in an unreliable and unsecured application process. Example 9. Missing digital signature certificate voids presumption of authenticity under Canada Evidence Act. No presumption of authenticity, integrity, or validity can be made in the absence of a digital signature certificate issued by a recognized certificate authority as required for a secure electronic signature under Section 31.42 of the Canada Evidence Act and the Secure Electronic Signature Regulations. Without such certification, the electronic signature does not meet the threshold of a secure electronic signature, and therefore cannot benefit from the statutory presumptions provided under Sections 31.5 and 31.6 of the Act. Example 10. Organization's burden of proof to authenticate documents. Relied upon, the organization bears the burden of proof to authenticate any document it intends to rely on. This requires demonstrating that the document is genuine, unaltered, and properly signed using secure electronic signatures or valid digital certificates. Without such proof, the document's reliability and legal validity are called into question. Under Section 31.6 of the Canada Evidence Act, certain matters, including those referred to in subsection 31.2.2, sections 31.3 and 31.5, as well as regulations under Section 31.4, may be established by affidavit. Where an affidavit is introduced as evidence, a party has the right to cross-examine the deponent if that person is an adverse party or under the control of one. For any other deponent, leave of the court is required before cross-examination can take place. Quiz. Identify the non-compliance scenario. Which of the following indicates failure to meet secure electronic signature standards? A. Clearly worded consent with checked "I agree" box linked to secure signature. B. No evidence of explicit consent such as unchecked "I agree" box or missing secure signature. C. Electronic signature with multiple unique characters attached to the document. D. Signature process meets all security and authentication standards. Answer: B. If you chose B, you are correct. Conclusion and best practices. Always ensure explicit, documented consent supported by secure electronic signature use, certified digital signature certificates to authenticate identity and document integrity, implement technological safeguards to prevent tampering and fraud, verify signature and certificate validity on receipt. Thank you.